America, I heard the defendants, but I couldn't piece the entire question together.
Counsel, please, because I made so many phone calls for people to assist us. One of them is just coming. I'll just take it briefly. Okay. The court is going to write. Yes. Hello. Hello. Hallelujah. It's not what I thought. It's not the person I thought.
Mute or something, so we don't hear a conversation. Or she should disconnect and connect back later.
Huh? No, I'm trying to connect back. I'm connected already. Okay.
Say go with himself.
Yeah. Thank you.
As God pleases.
Okay.
Yes, record or we should just continue. Okay.
Where is Megan? Was that? Yes, it's all right. Yes. You were asking whether he said the defendant was incorporated in the United States.
Yes, my lord.
Okay, what is your answer?
The defendant is incorporated, but yeah, they're incorporated.
In the United States?
Yes, my lord.
Okay. Yes.
So witness, do you know the name of the entity in the United States?
That would be Ashipa Electric Corp. I think there's an LLC that we registered for Texas.
Witness, would it be correct?
Yes.
Witness, would I be correct to suggest to you that the entity incorporated in the United States of America is called Ashipa Electric Corp?
It would be. I said it would be.
And Ashipa Electric LLC. Two different.
So I am not aware of two independent entities. I know that one entity was registered for when we joined the Texas program.
But we are clear, a line that none of them is referred to as Ashikpa Electric Limited, defendant in this suit.
Sorry, take that again, please.
The entity in America is not called Ashikpa Electric Limited.
Are you asking if it is not called Electric Limited? Yes, it's not called Ashok Electric Limited.
Thank you.
Yes.
I'm just looking for my to take a note. Thank you. So, witness, next question. Witness, would I be correct to suggest to you that Ashika Electric, the defendant was incorporated in 2014?
That might be correct. In Nigeria, you mean?
In Nigeria.
That might be correct.
If I showed you a document to confirm this, or you confirm that it did?
I would not, as the document didn't originate from me and I can't authenticate it. But it might be correct to say so.
Said incorporated in Nigeria in which year?
Nigeria in 2014, my lord.
Okay.
So, witness, please confirm that in Exhibit C1,
Yes.
Yes. That is your. Do you recall what Exhibit C1 is? Yes.
Exhibit C1 is what?
It is your chat, your WhatsApp chat with Mr. Olu Ajala on the 27th of March.
Okay.
Patricia, please. C1. I want to read to him.
WhatsApp chat with who?
With the managing director of the second defendant, of the defendant, the person that was talking. With Olu Ajala, the defendant's managing director and chief executive officer. Exhibit C1. I want to read something to him from there, but it's fine. So with that, I'm reading excerpts of the chart so that you can recall the chart. Okay. So, the chart starts with, bro, are you familiar with HTML5? Hi, bro, not familiar with professional use anymore. I have stopped using UI design for quite long, or can read up languages if the venture is worth it. You recall this conversation, sir?
I do.
So somewhere down the line, the conversation says, I have a developer coding controller currently. I need 2 additional developers and 2 web developers. You then responded, why so many developers? Is it for Ashika or another company abroad? Please, can you confirm to the court that Ashika referred to in this conversation is the defender?
The Ashika Electric Limited in Nigeria, yes.
Yes, the defender. Thank you, witness. I'm most grateful. Okay. So, witness, we'll go to the issue of founders agreement. You are done with the corporation and your thank you, sir.
Thank you, sir.
Yes.
So witness, can you confirm to this court if you have any executed agreement depicting you as a founder of the defendant? Do you have any agreement before the
So do you mean
as the founder of the defendant?
Please, I want to be clear. There are two questions there. Do you mean any agreements or any executed agreements?
Witness,
you said them.
Do you have an executed? Okay, so let's take it one by one. Do you have an agreement before the court that depicts you as a founder?
Yes, I have an agreement. It is not signed, but yes, we have an agreement. Can you hear me?
Yes, we got you, my lord. Lord is writing a note. So
Yes.
my lord has confirmed that indeed he has a document.
Yes.
No, I didn't say I have a document. I said we have an agreement, but we don't have a signed agreement, right?
No problem. Thank you, sir. Please, can you confirm what exhibit this is so that we can guide it?
Okay.
What document?
Sorry?
Go through and then identify to him, or he's going to do it himself. My lord, with the permission of the court, counsel to identify.
Yes.
He cannot go through the exhibits. The unexecuted agreement depicting him as founder. Pretty sure. So please, these are all the exhibits. The witness says agreement. So is that agreement I want? You will be the one identifying it. No. You're not giving the agreement that is not.
Have you found it? Is it an exhibit?
No problem.
Attached exhibit what?
No problem, my lord. We'll take it. Thank you very much.
Okay.
Witness, so that we're aligned and it's not a case we're not sure. Your counsel has identified T4 as the document you are referring to.
What is the document about?
Is the offer of employment dated in June 2020. Please confirm that is the document that you have also referred to as the executed agreement that refers to you as the founder.
No, it is not. I never said there is an executed agreement as a founder.
Unexecuted.
That is not. There are several other documents, and that is not the one. Like there's not a single one that refers to what I just said. So that document came from Olu Ajala. himself, and it was rejected as it was written in all.
Can you hold on?
Yeah.
Witness, sorry, hold on. So my Lord, it's you. My Lord is right down. So my Lord, the witness
Yes.
what the document is referring to. So can you please identify the document so that your counsel cannot and identify that document, the unexecuted agreement that you refer to, sir?
Okay. So based on my filings or pleadings, there is not one document that was executed. There is an array of documents that documented our conduct, having me as a co-founder. I'll give you one example so that my counsel can bring it out. There is an email from Oluwajala to me stating, and I quote, "Temitope Gutade, you are a co-founder that came at a later stage," right? That email did not originate from me. It came from Oluwajala, right? Stating, "Temitope, you are a co-founder." I'm quoting now, please. So my lawyer can please help me find that email. "You are a co-founder that came at a later stage." So all the agreements leading up to him himself admitting on record that you are a co-founder are the agreements I'm referring to. They are not necessarily signed and executed in the terms that you have put it, but they, by conduct, fully represent me as a co-founder.
Thank you very much, Mr. Bukade. Even though it's cross-examination and I'm supposed to restrict you and give you questions, it is important that courts, we are here to do justice. We are not here to point. So that is why, again, I'll reiterate my question so that you can then confirm your answer to my question. Witness, before the Honorable Court, do you have an agreement, executed or not executed, where you are referred to as the founder of the defendant?
I'm trying to be honest with this question, right? And
sorry, sir.
I'm trying to be honest with you, right? And I don't understand the legalese of an agreement, okay? But we don't have a document that is signed by both parties stating that you are a co-founder. That is what I'm saying on the one hand. But we have a series of...
Okay, sorry, sir. Just hold on there, sir. But do you have an agreement that is not signed? It's a contract, an agreement that refers to you as a co-founder of the defendant.
Yes, we have a series of them that you need to look at together. We do.
What exhibits are they, sir? So that we can identify them. You have to be your documents before the court so that I can examine you based on that. And that is why
I understand. Please, my barrister can please help me check. There is a first what is it called? Email from a transcript of my conversation that came from me to Oluwajala. That should be sometime around maybe June, between April and June. Can you hear me?
There are a lot of documents. No problem. Hold on. So you want him to identify
a series of documents.
The email.
A series of documents.
Well, just to clarify that said the agreement is referring to email correspondences. As an agreement or a document before the court that identifies him as founder, co-founder. I think that we can do.
Okay.
Yeah, these are documents that suggest as co-founder. A whole lot of them.
Okay, but there's none that is an agreement or a contract.
No,
okay, thank you. And that's what that was my question.
Counsel, I hope you know you have a limited time.
Yes, my lord, we have limited. That's why I'm taking them issues by issue, so that it was just to. I didn't want to start. Don't talk. It's just or no. I didn't.
Okay.
So witness, let's go to your employment now. For how long were you employed with the defendant?
That would be between March 28th and January 31st. Sorry, March 28th, 2020 and January 31st, 2021.
Thank you very much. March 28th, 2020 to January 31st, 2021. Thank you very much.
Yes.
Witness, in terms of your employment, do you have before the honorable court an executed employment letter?
No, I don't.
Yes.
Witness, would that be correct to say that as at the date of termination of your employment, you were still negotiating the terms of your employment with the defendant?
That is completely incorrect.
That's
You were still negotiating the terms of the employment with the defendant as at the date of termination of the employment.
okay.
That is
That was-
completely correct.
Yeah, but when I say completely incorrect, I mean,
No, sorry.
Okay, go on, please.
There will be opportunity for examination. So your counsel will give you that opportunity to
Okay.
the background story.
Yes.
So witness, in your pleading, you are alluding to the fact, or your evidence, you are alluding to the fact that you are internationally recognized and a prize winner IT expert, and so you did not need to provide evidence of your qualification. Would that be correct to say that?
Yes, you would be.
That was your evidence.
I've answered. I said you would be.
Yes, my lord is writing. I can see my lord, and when my lord is
Okay.
So he said he was what?
nationally recognized and prize winning acclaimed award. So he didn't need to provide evidence of qualification before this honorable court, and he said that's correct.
No, before this honorable court. No, that I'm not sure that is what I said. The what you're referring to is the conversation between me and Olu Ajala, and I said, and the response was to Olu Ajala, not to this honorable court. I don't know if that makes sense.
No problem. I'll read your evidence to you.
Okay.
Yes.
And I just want to read the claimant evidence to you.
Is it part of the chat?
No, it's in the pleadings.
Okay.
I apologize, my lord. We're hoping the witness will just confirm this. We apologize, my lord.
Sorry.
Okay, so paragraph 11E of your reply. Prior to joining defendant, the professionalism and competency of the claimant is well documented. This is you, sir. Nationally and internationally, you are very documented. As the technical founder of Phoenix.com and a holder of the National Software Excellence Award. So the claimant denies any knowledge or conversation or knowledge of programming language and avers that he didn't need to take his already well publicized competencies. That's your evidence, sir. So I'm saying again, you confirm that indeed, on the premise of this, you have not provided this honorable court with any evidence of your qualification because it is nationally and internationally documented. According to you, sir.
Well,
we have challenged qualification.
And that question is a little bit too long for him to.
Okay, my lord. We take it, my lord.
Assuming it's going to be useful to you.
Yes, my lord.
The answer.
No problem, my lord. We'll just restrict it. With that, before this honorable court, you don't have any evidence of qualification before this honorable court.
I don't.
Your qualification as the software technical person.
Well, I don't, but before this court, I have admitted that I was a student at Carnegie Mellon University. Carnegie Mellon is the best computer science school in the world, right? That's one of my qualifications that I've admitted before this court when I was being sworn in.
What's the name of the school? I didn't get it.
Carnegie Mellon University. When I was sworn on oath, one of the questions I was asked is where I was or what I was doing.
When you were sworn on oath, one of the questions you were asked where you were. Or what is it? Is that what he said? Sorry, witness. I didn't get that, sir. When you were sworn on oath.
Yes, one of the questions that my lord asked as part of the stuff was what I was doing at the time.
No, my lord didn't ask you any questions. Your counsel asked you a question, please.
Well, okay, but one of the questions I was asked is where I was at the time, and I mentioned being a student at Carnegie Mellon University.
That you are currently a student at Carnegie Mellon.
Yes.
That was at the date.
That was what?
When your last date were informed.
Not the last date. That was the very first time I was placed on oath, I think.
Okay, so in the course of trial of this matter, right?
Yes.
Okay, but not as at 2020.
Not as at 2020.
Thank you, sir. So witness, we have to move past now. In paragraph 7B, you had stated that you were going to rely on a page 2 of the defendant profile as authored by Olugbenga Ajala. Okay, let me take it again, my lord. I apologize, my lord.
Yes.
My lord, witness in paragraph 11B of your reply, you had alluded to the fact if you're going to rely on a 2-page document. Can you please identify this 2-page document where the defendant or the managing director admitted that the company was moribund or was not operating before you joined?
In 11B of my reply, I'm not sure I can see.
11B of your reply, just to read for him, my lord. The business did not pay gradually from 2014 and had come to a halt before the new team was set up to commence afresh. The claimant shall rely on the page 2 of the defendant profile as authored by Olugbenga Ajala to meet the admission of major setback.
Okay. I would rely on my counsel
profile that I want you to help identify which of the documents exhibit what.
I would rely on my counsel to help find the company profile that I provided to him. Yeah.
Page 2 of the profile where we admitted major setback. Let's go to another person. So paragraph 11, in paragraph 11, okay, we've dealt with that.
No, I think we have mentioned it before.
Dealt with that. Yes, madam. It's competence. Professionalism. So, witness, please confirm to the court that the first employment letter report from the defendant was the 15th of June 2020.
I didn't get the question. I should confirm to the court that what?
The first employment offer of employment that you got from the defendant was 15th of June 2020.
No, it was not on 16th of June.
Sorry, sir.
Sorry. Did you say 16th of June?
15th June.
It is possible that, yeah, it is possible it is 15th of June, thereabouts, yes.
No, I can bring back the exhibit.
Just go on, please. It's possible.
No, I need to confirm. Can you please
Could
confirm?
say or thereabout.
So that,
Okay.
that's it. Tell him. That is it now, 15th June.
Yeah.
16th July, I'm going, but that's 15th June. So please, can you confirm to me the date so that I can confirm? I don't want to hear about question answer. Please confirm to him.
That's the date.
Can he hear you?
Yeah, yes, let's go on. That's the date then.
Okay. All right, thank you. And witness, please confirm to the court that you rejected the offer outrightly.
It was rejected. I wouldn't use the term outrightly.
Thank you.
But it was rejected.
Okay. Please confirm to the court that in response,
sorry, say that again.
I'm waiting for my lord. When my lord is ready,
That he confirms
that the offer of 15th June 2020 was rejected. Confirm that I didn't put out rightly. I said he has rejected.
You put it outrightly, and I said I wouldn't put it as outrightly.
No problem.
yes.
Witness, please confirm to the court that in response, on the 16th of July 2020, you then sent a revised offer with comment to your employer, the defendant.
I did not send any offer on the 16th of July. Any revised offer. You say?
So, my lord.
Yes.
That is exhibit C4 and C5, my lord.
Yes.
The document you're referring to was not sent. So the word here is sent. The document was not sent as you have put it.
Was not signed as well.
Was not sent. You said, did you send? And I said, I did not send. So I'm not saying there's a document, but there was no action of sending, like you said.
Okay, but you presented it to the defendant, alter ego, Undo Ajala.
So let me clarify. Let me clarify what happened. Right. When he sent me the first one that you referred to on the 15th of June, in Google Drive, you can have a document that two people or multiple people are working on at the same time. We agreed.
So let me just get you right. So The defendant sent you an offer of employment, Exhibit C4, on the 15th day of June 2020. You have confirmed that. On the 16th day of July 2020, you then updated that document with your comment.
No, I brought it to his attention.
Included in it.
I brought it to his attention on that day to look at that document.
Sorry, sir?
I brought it to his attention on that day to look at that document.
But witness can confirm that it is C5's date 15th July 2020.
Yes, maybe I should explain. I think the question is actually missing what happened, right?
No, that's what happened. I'm not asking about what happened. If I need to know what happened, I'll ask you a question about that. I'm just
so what is the question, please?
So, Exhibit C5 is 16 July 2020.
Okay, that was what's the question?
Yes, and it has your comments.
Yeah, what is the question, please?
The offer of employment of 16 July 2020,
okay,
where your revision to the offer that was sent to you initially by the defendant.
Again, if there is a document that said I revised on the 16th of July, that document did not come from me as you have put it.
Okay, I've been better to say the
sorry, my lord.
Yes or no, and then
okay. As a government, we take the end of the court. Witness, so you
Exhibit 5. Yes.
Exhibit C5.
C5.
5, my lord.
Of 16/7.
16/7/2020.
Yes. Mm-hmm.
Yes. With the edits on the line, can you please identify that those edits that you have on the line for your inclusion in the terms of offer? Let him be the one to identify it. The underlined text.
So when my inclusion on what?
In the offer of employment. The underlined text.
So will I be shown something?
It's going to be shown to you now so that you don't.
Okay.
You use my Lord's phone to show.
Okay, you want to?
The underlined one.
While I can't see clearly, I remember this document. So this is one of two documents on the revision. Yes. One of two documents on the revision. Yes.
Okay. We'll come to the other document. You confirm that the underlined portion were your revision on this document.
If this is the one I submitted, right, to the court, yes, I'm relying on it.
We haven't started our case. You submitted it.
Okay, yes.
Thank you, madam. I know he has confirmed.
Okay.
So the date, witness, till the date you left the employment of the defendant, this offer on C5 was also not executed by party. Was not signed. Was not signed.
Yeah, it was not.
Thank you. So that's for your employment. Witness. Exhibit.
Yes.
In exhibit C3, the transcript of the meeting with Danny and the other engineer. Do you recall C3?
Okay, please go on.
Do you recall? That's the question.
If you tell me what the content is, I don't know what exhibit C3 is, please.
Okay, so I'll explain it to you. It's called in your process. The transcript of the meeting dated 1st day of June 2020 recorded by you.
By me, okay.
Yes, you are the claimant.
Okay, please go on.
So in paragraph 2, read from the
From SBC3.
paragraph 2 of the email from the claimant to Olugbenga. Paragraph 2. Please confirm that the claim period for the vesting shares was 4 years with a 2-year period, which requires transitioning to a salary regime, so that hardship. This is your email. I'm reading your email. You're with your client, your partner can confirm. Number 2,
Okay.
4-year vesting schedule, 2-year period requires any transition to a salary regime, so that hardship do not be the reason why people cannot invest in. In the event that such salary figures are not in place, being a reason that vesting cliff should be rolled back to 1 year. So,
Okay.
sir, I ask again, by virtue of Exhibit C3, you agree with me that the shortest cliff period for the vesting of shares is 1 year?
I do.
Sorry, sir?
Yes, I do.
Thank you, sir. So, intellectual property rights agreement.
This, of course, all these documents are in the court's file.
Yes, this is the first one we are going to read.
Okay.
Counsel to confirm before I tender it through him.
Objection to this. Whenever this is complicated evidence.
Is there?
Limited evidence as it is.
By who?
If not, this one. Want to tender it to your clients? It's fine.
Okay.
So I will. You want it to go in?
No, my lord, we'll tender it to our own witness because our witness was one. We wanted him to identify it because we wanted to ask him questions based on our counterclaim of this, and we didn't want to have to report him. His counsel wants us to. It's not a problem. Witness, sir, please, do you recall executing an intellectual property agreement with Ashikba
I
on
do.
the 19th day of August 2020?
I do.
You recall?
I do.
Very well, thank you, sir. Will I be correct to suggest to you, sir, that by virtue of that agreement,
I have stopped hearing the audio. In case you're talking to me, I have stopped
I'm
hearing
waiting
the
for my
audio.
lord, so you are correct.
He recalls executing an intellectual. Yes.
Agreement
Property.
with the defendant company,
Yes.
19th day of August 2020, my lord.
Yes.
So, witness, would I be correct to suggest to you that by virtue of that intellectual property agreement, all innovation, invention created in the course of your employment with the defendant belongs to the defendant?
That would be correct.
Thank you, sir.
What belongs to the.
Sorry, my lord.
You said
Inventions, innovations, and innovations belong to the defendant by virtue of that document, my lord.
Yes.
Witness, still on the issue of intellectual, prior to working with the defendant, in the short period that you have worked in March to January, what did you work? Have you been previously employed?
Is that the question?
Prior to March 28th March 2020, you were employed. You were employed previously.
Yes, but I wouldn't describe it as short the way you have characterized it. But yes, I was.
Prior to March 28th, 2020, I was employed, please.
As what? No, just employed. Because I want to ask him about his understanding of a couple of things. And as whilst with the defendant, you were the chief operating officer for a period of time.
Yes, I was.
I was a what?
Chief operating officer for a period of time.
Yes.
Would I be correct to suggest to you that you are aware an employee has the duty of confidentiality with respect to the business of his employer? In your previous employment as you of the defendant company, do employees naturally just talk about their employment casually, or they have the duty of confidentiality?
Please, can you ask just short, specific questions? Like this question is a bit. Can you just split it up, please? Specific questions.
Maybe you could break them down.
Witness, you understand the concept of confidentiality?
Okay, I do.
Correct? Do you understand the concept of confidentiality? To hold an information confidential?
I do.
Okay. So do you agree with me if I suggest to you that an employee has a duty to handle employer's information in a confidential manner?
Well, I would agree that information that is designated as confidential should be handled with a reasonable care of confidentiality. But I wouldn't say all information like a blanket thing.
Okay. So you would say that information that is confidential, that is not in public domain, to be treated as confidential by the employee.
Yeah, I would expect that, yes.
Thank you very much. Thank you very much, sir. So the last set of issues, the last issue, witness, in your exhibit, I want to go to your exhibit C7.
Yes. Yes.
Exhibit C7.
What is the title?
It's just
Correspondence.
But I don't call it the letter of dismissal.
Okay. Actually, I've just been informed that they want to put off the light. That's our diesel has.
Wow. But John. Well, I've not spent 1 hour. No, don't rush. You took.
I was hoping that since it's not in Nigeria, we would have finished this thing today.
But we'll try.
But you are not doing badly now.
So,
Uh,
Thank you, my lord.
this document,
so please just go to the question.
as copied, so my lord, we are on exhibit C7.
Okay.
Please confirm that the reasons you are stated on exhibit C7 for the termination of your document and nothing beyond those issues.
I should state that what?
The issues stated in exhibit C7 were the only issues given for termination of your employment and nothing beyond those issues listed in numbers 1 to 4. You are opposed to a leveraging partners expertise. You continually estimate the process of consumer electronics. You do not understand the importance of keeping the minimally viable product. The worst part is that you have not been able to accept faults. There are no allegations that you committed fraud or misconduct or any of those. These 4 reasons were the reasons why your employment was terminated.
Oh, they are not. They are not the only reasons.
In this, the letter notice of dismissal.
Yes. So in February,
The notice of dismissal, I'm asking about the notice of dismissal that you have tendered because you don't have any other document for the court.
I do. I have another document before the courts. In February, let me state the document so my lawyer can bring it out.
Okay.
In February, one Shokunbi Abioye, Oluwajala wrote me through one Shokunbi Abioye, telling me that one of the reasons I was dismissed is because of bad behavior.
Is it not that letter?
You don't know this letter, my lord, and it's not before
February. In February, it is. I gave it to my lawyer to put before the courts. So please let him find it out. And Abioye Shokunbi wrote an email to Ajala.
And I know that there's no Abioye Shokunbi in this file, but my letter.
Is that the last question?
Let me ask another question while you're looking for it. So please, sir, please confirm that you were given an option to finding a way for a clean exit by exhibit C7. Would I be correct to say that?
That is
I'm open to finding a clean exit. That email said that.
That is incorrect.
Sorry, sir?
Even though those words were on that notice, it would be incorrect to characterize it that way.
No, so I'm asking if the exhibit C7 that you received, the letter inviting or telling me that you were open to finding a way to give you a clean exit.
Those words were in that letter, yes.
Thank you, sir. Did you make any attempt documented to see the opportunity for this clean exit?
Either documented or not, I made
no
such attempt.
You didn't do it. If you didn't take a documented approach, please confirm. I'm asking.
No.
In response to that, thank you, madam. He says he did not take that. Well, because exhibit C7 is dated, and for us it's important that in 2 weeks' notice. Please confirm that you received exhibit C7 on the 14th day of January 2021.
Is that the notice of dismissal?
Yes, sir.
Yes, the email came on that day, yes.
The 14th of January, thank you, sir. And please confirm to the court that at the end of January 2021, you were paid your salary that you had received in the preceding months.
The salary that I worked for the month of January, yes.
January 2021.
Yes.
Thank you, sir.
That should be all.
That's all, my lord, except they didn't bring this document that this document by Shokumbi. Thank you. Give me.
This called Let me look at it.
All right.
But just so on this issue of whether or not he was terminated for any other reason, because his case is that he was, and we are saying, even though court that it was termination. So if I can identify any other reason for its termination, so it's not shut out. But we are
No, you still have your final written address.
as the court pleases, my lord. We're most grateful, my
You
lord.
still have your final written address.
I think my lord, we have covered the ground.
Okay. Any reason?
We are most grateful to the court.
Yes. Okay. Witness, they have finished with you.
Thanks, my lord.
Yes, and so you're free to go.
Thank you, my
You're
lord.
free. Would you want him to be attending court? You're free from attending any further session of this trial.
Thank you, my lord.
Okay. So, is there any other witness? Okay. Please give me a date for defense. That's all right. But honestly, I don't like this time they fix it. Okay. Now, when such cases come up, you just get up and remind the court that there's a matter for Zoom because it doesn't listed in the cost list, the electronic cost list and all that. Okay, it will be for Zoom too. Okay. Shall we say by 11? We will tell Abuja we want it, or 12. Okay, it's true. So you said 1st of July. Okay. Very well. So this matter is adjourned to the 1st day of July 2025 for defense. And it shall be for by Zoom and by 12 noon. Yes. Thank you. Thank you too.
Thank you, my lord.
Yes. Come on. The court shall rise. Okay, I'm not supposed to have this again. Okay. Thank you. Okay, I will sign at this. Yeah. Thank God tomorrow is Friday.